Hey, Attorney Brian Parker here. I got another exciting video. Today is building on what I've been talking about as far as the use and the foundation of, that is, the counter affidavit. And I want to try to emphasize and make this clear that the counter affidavit, whether it's required or not, you can't go wrong with it, is the bedrock of your defense. And it actually drops. You do this, you use all their paperwork that they've given you showing that they own the debt. None of it is what they tell you it is. And we'll look at a UHG versus my client, David Debtor, today, and we'll use the documents against them. And I just did. I just filed an answer that I'm going to give you and a counter affidavit and affirmative defenses that I just filed with a Florida court, and you can see how I want you to proceed if you choose with your law and your facts. But here we go. The counter affidavit essentially plunks from itself, which gets all the information from the lawsuit against you, drops into the answer. Once you've done the counter affidavit, it drops right into the answer and affirmative defenses. And then you can take that same information, counter affidavit, put it into your counterclaim and beyond. It looks like, schematically, conceptually, whatever, looks like this. Shazam. And you can see counter affidavit to answer to counterclaim and beyond. So the whole genesis, again, of this thing is create the best counter affidavit that relays your position, that relays your defense, and essentially it just opens and puts salt on the wounds that are their proof. So let's look at a couple of paragraphs of a lawsuit against my client from UHG. So let's put page 1 up there, Cindy, Shazam, and you can see at number 4, they're pointing above to the jurisdictional allegations, but they're saying we have a right to be in this court. So in my counter affidavit, I will put that up right now for you. If you look at counter affidavit page 1, Shazam, there's me immediately coming out and saying, attached to the lawsuit, they have a bill of sale and assignment that appears to be from New York, signed on March 30th, 2021, and does not have my name or my account number on it, and shows no assignment from the original creditor to UHG in this case. So that goes into my counter affidavit. I took the bill of sale that they say proves they have the right to sue my client and just gave it right back to them. So let's look at number 6 of the complaint. Cindy, paragraph 6, Shazam. And they are saying my client entered into a promissory note, and they call it the contract with the plaintiff, or one of its assignors. If you own something, you would not say, hey, you sold me the car, or one of your friends sold it to me. You'd say, you sold me the car. So why are they so wishy-washy? And that's, putting it mildly, ambiguous or downright deceitful. Either you got it or you don't. Why do you need to say that? By the way, this is a credit card, so promissory notes aren't part of any credit card litigation, at least none that I know of. It's a credit card agreement or a cardholder agreement, and that's a contract. But what they do is they're not sure either, so they put promissory note, and then they say in parentheses contract, and both have 2 different kinds of elements. So let's keep going. Oh, they say in 6, a copy of the contract is attached as an exhibit. It isn't, it wasn't. And I've yet to see it in many years of doing this stuff. Unless it's a creditor loss, and even then you're not going to see the client's signature. Number 7, let's put up number 7, Cindy, Shazam of the paragraph of the complaint. The contract was assigned to plaintiff. Well, there's no contract, and no, it wasn't. In fact, nothing that I'm about to show you shows any contract being assigned. It's just mere accounts, and we've already talked about that. So we've looked. Put up the bill of sale, Cindy, Shazam. And the bill of sale essentially says nothing. It says it's from Bank and Department Stores National Bank. I don't even know if it's a real thing. The bank does hereby trade sell. By the way, that's 2 entities, I believe. And then the signature's not department store's national bank, it's Citibank, but the signature is not dated and it is from an authorized party. Authorized to do what? By whom? This is not nonsense. Everything is a contract. You have to have terms. You have to have consideration. You have to have a meeting of the minds. We don't even know who the parties are. And they're saying that, along with the contract, says we own the contract. By the way, in the bill of sale, there is nothing that says contract. The only contract is between department stores, national bank and buyer. And the other contract, which, pro tip, they mention the master purchase and sale agreement. That's the forward flow agreement that is the basis of every debt buyer's sale and purchase. Ask for it. They don't want to give it up because it tells you secret stuff. Not necessarily that it's trade secrets, but it'll tell you that the debt that they got has no representations, no warranties. It's bought as is, but you don't see that here because that would kill their case. So attached to the lawsuit was also an affidavit of account. Cindy, put that up, Shazam. And that just says, if you read it, there's a bunch of charge-off accounts. There is no word contract or promissory note in that purchase, in that sale of account. I thought we were selling a contract. It specifically says, 6 and 7 says there's a contract. So, but weirdly, they say that thing before us, which is the bill of sale, it's true because we say in a separate document it is. And then they add to the lawsuit a certificate of conformity, Shazam, and that says, you know that thing we said before, the affidavit of account that was really confirming that assignment and bill of sale? Trust us, this is conforming, and yet it's signed in the city of Kansas City, which is, I believe, in Clark County. Yet they're claiming it was signed on April 1st on both times, the certificate of conformity and the affidavit of sale of account was signed in the same county. And on the certificate of conformity, look at the attorney at law. Her name isn't there. Why not? But I did some work, and that's a ticket. That's her bar number. So I went to Missouri and got the bar, and it gave me that person's name. But why wouldn't her name be here? And is that her signature? And is she in Platte County, which is not in the city of the Kansas City, is not in Platte County, from my research. I could be wrong, but I've got plenty of stuff online that says she's in Clark County. So that's in my counter affidavit, all right? So if you look at my counter affidavit, page 3, Shazam, I write specifically what I just said to you about the complaint. In paragraph 6 of the lawsuit, UHDG states it's attached a promissory note to the complaint that is not attached, and they claim I entered into with the plaintiff or one of the assigners. And then I quote paragraph 6, and then I say, if plaintiff owns the debt, how does it not know if I entered into the promissory note with plaintiff UHG or assigners? Be human. Don't be an attorney about these things. So that's more appealing to a judge when you're self-representing and you're going, I don't get it. The emperor's not wearing any clothes. Am I missing something? Judge will get what you're doing. But those three things, the bill of sale, the affidavit of sale of account, and the certificate of conformity, back to my original premise, is in your affidavit, your counter affidavit. That now will plunk into your answer. So you would take your answer, you take your counter affidavit, and if you look on page 2 of my answer, Shazam, there's the bill of sale and assignment, and I'm pointing out what's wrong with it. Also, you can see the affidavit of sale account. I'm pointing out what's wrong with it. There's the certificate of conformity. I'm pointing out what's wrong with it. So why am I doing that? I just took it from the counter affidavit. The work's already been done. Drop it into my answer and go after them. Go after each paragraph like you mean it, because you do. They're BSing you, and BSing the court and thinking you're just gonna, okay, I owe it. Nonsense. There's no proof generally or specifically to this that you owe anything. You don't owe a promissory note, which is the lion's share of their allegations against you, and that they assign to someone else with no proof. So my point in telling you all this is to remember to focus on the counter affidavit with your facts and your laws, whether you're in a state that doesn't require it. Now, when I say require, for example, in Michigan, you must counter an affidavit of accounts. Otherwise, it's automatically held against you and you lose. All that's talked about then is how much you owe. In Florida, it's not as specific, but you've got to answer any allegations against you. So if they've got an affidavit or something that's going to kill you or work that case against you, have your counter affidavit. If you're in a state that doesn't mention anything about accounts stated, have your counter affidavit. Never miss an opportunity. It's a marketing concept. With the judge, never miss an opportunity to make a great impression. And your counter affidavit takes their documents, uses against them, and then you put it in your counter affidavit. Now you've done the work. When that's done, and I'm doing half that work for you, attached to the membership website, collectionstoppersolutions.com, is my template that I just used, is my answer that I just used. You can have them. Just conform them to your law and your facts. I'm not telling you how to practice. And you're almost there. You really are. You're going to look at this. I'll attach the complaint that I went against here. And I just showed you a couple of the paragraphs. They're saying things that are out and out not true, using legal terms that don't apply. Why? There's an arrogance like you owe the money, or 90% of these cases are going to go into default. Why would they do the work? Well, you do. You live in that 10% with me, and we're trying to expand it. Use my documents against them by using their documents against them. That's kind of tricky and nice. So remember, if you like what I'm saying, ask me for more and I'll give it to you. Love, like, subscribe, and we'll keep rocking it out. And again, this is all on my membership website and the attachments you need to not only have your day in court, but to win, baby. Win. Thank you. Bye-bye.